Hello everyone, my name is Pamela Large Moran. I am a lawyer at PLM Law in Charlottetown, and thank you for joining us to hear our free presentation on Indian Day School settlement claims process. I just want to be clear that we are not class counsel, we're not Gallings, we're not the administrator, Deloitte. We are an independent law firm with experience working with Indigenous community members, residential school survivors, and now day school survivors. And so we're giving some general advice here, some general information, in this video. It's for information purposes only and isn't to be considered a solicitation for legal services and isn't to be relied upon as independent legal advice. So I'm going to try to provide some good overview for you in terms of this claims process. So this first slide is just briefly who I am. I've got over 30 years experience as a lawyer focusing on social justice issues and human rights. I've also practiced as a mediator with a restorative focus. And I worked, as I had said previously, in the Indian residential school settlement process for almost 8 years and have a various background in personal injury law as well. I have with me here as well an articling student, Michael Sema, who's a member of the student member of the Indigenous Bar Association, and he's articling here with me. He's originally from Nova Scotia, Mi'kmaq, and he grew up in Toronto. He graduated with his law degree from the University of Saskatchewan and is also the founder and administrator of Education as Our Buffalo, which is a Facebook group of over 13,000 members. And he's also the moderator of the Indigenous Day School Survivor Facebook group of over 18,000 members. So just briefly as an overview of what I'm going to talk about in this short 30 to 35 minute video presentation. 4 areas. I'm going to talk briefly about the settlement itself, which was called the McLean Federal Indian Day School Class Action Settlement. I'm going to talk to you generally about the legal assistance that's provided for under that agreement. I'm going to go into the claim form and discuss some about supporting documentation, and then talk about sort of that claims reconsideration or appeal process. So the McLean Federal Indian Day School Class Action Settlement was certified in June of 2018. The final settlement agreement was announced in March of 2019, and Justice Phelan of the federal court, approved the settlement in August of 2019. January 13, 2020 was when this claims process opened. So that's sort of a bit of an overview, and as I indicated, I'm independent legal counsel that's now providing assistance to class members or survivors in this claims compensation process. So some key issues about the settlement agreement. It's quite a large settlement with class member size estimated to be 140,000 people. It covers similar harms and physical and sexual abuse similar to the residential school settlement agreement. There are 5 levels of harms and abuse within the compensation grid, ranging from levels 1 to 5, or compensation of $10,000 up to level 5, compensation of $200,000. And some of the particulars of that's laid out in the abuse or the harms grid, which I'll get into a little bit here shortly. The deadline to submit a claim is July 13th, 2022, so there's still over just under 2 years to submit a claim or to put your application forward, and there's a possible 6-month extension. So the settlement agreement itself provided for one law firm, class counsel, Gowling WLG, to provide legal advice and services. This free advice is provided via 1844 toll-free number and a call center. There's information sessions, and through their website they're providing information. Gallings, however, does not gather supporting documentation that may be required at the higher levels claims, nor do they submit claims directly to the administrator. Also under wills and estates, because there is provision in the settlement agreement for claims to be brought on behalf of a deceased survivor. And so Gallings doesn't provide claimants with personal estate legal services, such as where there's no will or estate executor, or no administrator for a non-reserved survivor. There has been some criticism in the past of the assistance Gallings has been able to provide, particularly in Atlantic Canada, and I've just put forward in this slide presentation some news reports, mainly from CBC, The first one came out of Atlantic Canada here, where Atlantic First Nations leadership sought emergency assistance with the tsunami of work from the Indian Day School claims. So letters were sent to the Prime Minister's office, and there was a request made for immediate additional legal, financial, and mental health resources. So this day school settlement agreement, unlike the residential schools settlement agreement, does not provide for payment for legal counsel. It doesn't provide for sort of, as well, some mental health resources. The particular, type provided under the previous residential schools claims process. So there are some differences, and I'll talk about that a little bit more. So that's just a little bit more of what the Executive Director of the Atlantic Policy Congress of First Nations Chief Secretariat communicated about needing help in these communities. It noted that community members need help and former students in navigating the legal terminology and some of the detail required in the application forms, and while at the same time getting some emotional and cultural support. So fast forward, because of this kind of concern raised, as well as other concerns raised by other leadership and other communities, in June of 2020, the federal court provided an order allowing day school survivors to get easier access to their own lawyers, so lawyers of their own choice. One of the survivors that put forth in this court order, to seek the court order, survivor Nehautau said she believes that independent legal counsel can provide more face-to-face contact and services that are specific to the community or the nation and with a focus on healing. So on that basis, the court did provide an order allowing for there to be more access to justice, whereby survivors could choose to have their own legal counsel. And so that's who we are. We're here in Atlantic Canada, but we're also working, across Canada via internet, Facebook, the web, our website. We have a toll-free number, obviously telephone work, and assisting survivors across the country. As I indicated, we have significant experience working in the Indigenous community and with residential and day school survivors. One of the things that's valuable in terms of getting your own lawyer, your own support, is that in my view, we can work hard to assist you in putting your best claim forward. And putting your best claim forward, very much a part of that could be, seeking further supporting documentation to support your claim. And I'll talk about that because in the higher level claims, putting your best claim forward to, make your case as strong as it can be, is important. And there are some requirements for documentary support if it's available, and if it's not available, there is an alternative of Part 6 in the claim form, the sworn declaration to say that everything that you're putting forth is true, including your narrative, including your story, and also that the records are missing or you can't get any more documentary support. So anyway, so some of the value in having your own chosen legal counsel to assist you in this process. As I say, we'll work with you individually and ensure your privacy and confidentiality. We support traditional healing and sharing circles, that type of thing. And we're also providing services that's all part of this to advocate for you under the claims reconsideration or the appeal process. So if your claim or your application comes back at a lower level or is denied, there is a reconsideration or an appeal process. And so, again, we're assisting in that as well. I mentioned the wills and estates, legal assistance for survivors, and some of the important legal requirements for that. And again, we're assisting clients with that. So just a broad overview, the claims process and the claims form. The claims are strictly a paper filing process. I've indicated the levels of claim from 1 to 5, really depending on what happened to you as a student at the day school. It's really important to put forth your full story with good detail, and understanding, I think, some of the levels and some of the criteria under the levels, 2 to 5 in that abuse harms grid that I'm going to be talking to you about. Once the claim form and any supporting documentation, if it's obtainable, is complete, then they're sent to the claims administrator, which is Deloitte. As independent counsel representing survivors, that's what we do as well on your behalf, is put that all together, make sure it's complete, important information is in there, and any supporting documentation that can be obtained, and we submit it directly on your behalf to the claims administrator. The claims administrator determines eligibility, level of harm or abuse, and the compensation amount based on the information and the supporting documentation you provide. And then I mentioned also about the reconsideration or the appeal process. So just generally, kind of an overview of a step-by-step how to do a claim. The first thing to do is to determine if you attended a federal Indian Day School and whether it's eligible under this claims compensation process. There is what's called Schedule K to the settlement agreement, and that sets out over 700 Indian Day schools that were determined in the process to be eligible. There's also time frames during which those schools were run by the federal government. So you'll see on Schedule K not only names of schools in the area or the nation that they were near, First Nation, or the community, but also the time frame. And so here's an example here. For example, Lennox Island Federal Indian Day School is here where I live in Prince Edward Island. On Schedule K it is listed as that, and it shows an opening date of 1869 and a closing date of September 1st, 1987. So anyone who attended Lennox Island Day School during those years is eligible to claim under this compensation process. So how to do a claim level 1, what information is needed? And now level 1 is more straightforward, and there's very little documentation required. Generally the information needed is the years attended, the requirement of a witness to your claim form. Unlike the higher level claims 2 to 5, you don't have to write a narrative or the story or description of what occurred to you there. If you choose to claim level 1, that's not required, nor is there any supporting documentation required. Provide any form of government ID is very important on level 1. And if you have no ID, then you can use the sworn declaration. So again, level 1 is quite simple and straightforward. But there's been a lot of concern raised in many communities that the way the process is sort of set out in the paper requirements is that many survivors are settling for only level 1 when in fact they may be eligible for a higher level claim, a higher level of compensation. So there's just an example of what Part 4 looks like for level 1 on the claim form. And it describes what level 1 includes, such as belittling or abusive language or humiliation, threats of violence, sexual comments or provocation, or physical abuse or harm, that resulted, was punishment or discipline or whatever. It's also important, though, for everyone to understand that this compensation process does not only include claims that were claims coming out of abuse or harm is suffered at the hands of teachers, principal, school officials. It also includes if you suffered harm or abuse at the hands of another student, or even a third party that came onto the school property or was involved in a school activity, that physically or sexually abused, or verbally abused, you as a student. So again, with respect to level 1, it's our view that this is straightforward, but it's also important that in looking at this entire claim form that you look at the rest of it and look at what is covered under levels 2 to 5, the higher level claims. Because it may be that you are in fact, owed more than the $10,000 or entitled to more than a level 1 claim. And so the level 2 to 5 claim can be, it is quite important. It's good, and it is important to get advice on it, legal advice on it, especially if you're unsure of what level you should seek or what falls under level 2 to 5. So, in terms of information to be provided, evidence of attendance, so school records, the form says that's required, and it could include things such as report cards, photographs, letter from a teacher, a yearbook, that kind of thing. So for level 2 to 5, evidence of attendance is required unless it's missing or not available. Then you can complete the Part 6, the sworn declaration. And that is sufficient to fulfill that evidence of attendance. Now I just want to give a trigger warning in terms of the abuse and the harms grid that I'm now going to get into and talk about. Obviously it deals in some detail with the specifics of some of the abuses and harms and the levels for compensation. So I'm very sensitive. I'm very sensitive to this, and I understand that this can be triggering. Even reliving these experiences or hearing about these experiences can be triggering. So I just want to let you know that I'm going to be putting this slide up next. So this is part 5, what we call I call the abuse harms grid, and these are what sets out the level 2 to 5 claims. And you'll see the top part of the grid deals with sexual abuse and harm, and the various levels depending on what particularly happened to you as a student at the school. Physical abuse also is on the bottom part of this, and it talks about, again, different types of physical abuse or assault. And what's important about this is that generally to succeed in a physical abuse claim, there must be some kind of a harm caused as a result. So you'll see for level 2, it's serious but temporary harm, and this could include such things as being knocked out, losing consciousness, or broken bone, or just even what we now know as a concussion, where maybe you were hit on the head or was pushed and hit your head, and maybe you weren't knocked out, but you had headaches for a period of time afterwards. You felt ill, you had dizziness, all those kind of things that indicate a concussion possibly. In the higher levels, 3 to 5, the requirement is more of a permanent or long-term harm or injury, and that can include impairment, either physical or mental. So mental includes things like psychological impairment, such as PTSD, emotional issues, all of that. And so, that's included under levels 3 to 5, and disfigurement as well, scarring, things of that nature. And it's really where, especially in the physical abuse part of the grid, where some supporting documentary evidence could really, really be helpful if it is obtainable. And I'll talk a little bit more about that. Again, just finishing off on this abuse harms grid, you'll see at the bottom where you select the claim level, and the selection of this claim level is very important. It's important to really understand your story that you're putting forth and where that may fall under this harms grid. The other thing about this abuse harms grid is that it's not exhaustive. So something might have happened to you that you're not sure how or where it falls into this harms grid or what level, and that's where really getting that good legal advice and support can be really beneficial. So again, this just goes to what I just indicated. The narrative or the story that's required to be put forth, the details are necessary, and so as much as you can remember, so that the assessor at Deloitte that's determining your compensation can really make a determination as to what level, what of those 2 to 5 higher levels your claim falls under. And so again, I have a lot of experience in dealing with this similar harms grid in working with the residential schools, and it's important to know what questions to ask and to really get clarification, or to even edit your narrative or your story to put forth the strongest case, the strongest claim forward that you can. And so that's what we do as independent legal counsel with experience in this area. We're really able to delve into that and really give some good legal advice and assistance on that. Again, what I previously said, gathering supporting documentation is very helpful if it can be obtained. And so I'll give you an example of a dentist abuse claims, these type of claims that are being put forth. And I think there are many survivors out there that probably may have already submitted and not realized that things like a dentist abuse claim can be and should be included. And there's certainly good argument that they may fall under a higher level 3 or 4. And so things like what we're hearing where children survivors were, a dentist came to the school, or the school sent students out to the dentist and might have suffered abuse by the dentist, but also we're hearing a lot of teeth being pulled without freezing, really, quite traumatic and quite difficult situations. And so, depending on the time frame and what occurred, there's possibility that those kind of dental abuse claims, fall under level 3 or 4, and also, some of the documentation that could be put forth could be fresh evidence or a report from a treating dentist or an x-ray to show that those teeth have been pulled. Because what I'm seeing as well is many of them were not baby teeth but adult teeth, and so didn't grow back. So, a dentist could confirm that kind of thing. Again, where there isn't documentation or further evidence or support, the Part 6 sworn declaration can be used to assist in that. But where it can be gathered, or there is evidence or documentation to be gathered, it is important, to strengthen your claim and bolster your claim that way. Again, here's more, here's more information on the documentary support. This kind of gives an example of the kind of documentary support that can be provided. And again, you'll see under their various levels where it says required, and those asterisks refer to if it can't be obtained, then you can use the Form 6 statutory, the Form 6 sworn declaration. So, phone's ringing there. A little bit of a distraction, but anyway. So there's sort of a little bit of an explanation of that. And as I say, where good information, even by way of an expert report, a medical or a dental expert report, that's one way that we can really assist quite well as independent legal counsel and representing our clients. So there's just some examples of the harm and some of the required maybe support for it. Level 1, there's nothing required. Level 2, could have been a physical harm where maybe there was some bed rest after, or stitches, and obviously that can be observed, or a doctor can confirm that you had stitches somewhere, those kind of things. Things like the higher levels, PTSD, depression, anxiety, information can be obtained on that. As you get to as you go up to the higher levels, the more documentary evidence and the more you can provide, will make your case stronger for sure. Again, there's always that fallback if supporting information or documentation cannot be provided or is missing, then you can use again that statutory declaration, that sworn declaration. This is again just an example of what I had said previously about a dental claim, and maybe it's expert dental report, historical records if they're available, all of that. Again, just more discussion about the Part 6 sworn declaration. And what a sworn declaration is, it's signed by the claimant and one of the following guarantors that are listed on this slide, but also listed in the claims form. They can be a notary public or a commissioner of oaths, elected official, or community leader, such as a chief or counselor, or another professional, such as a lawyer, doctor, physician, accountant, teacher, police officer. So that person signing that sworn declaration is just swearing to your signature. They don't see the entirety of your claim. But again, it's my overall advice that put your best claim forward with supporting documentation in those level 2 to 5 claims if possible. The reconsideration process can be time sensitive and somewhat legalistic as well. So when you put your application, your claim in, or with the assistance of us, again, our job is to help you to put your strongest case forward. And again, these slides are just talking about the best support and various ways you can strengthen your case. So the written narrative is required in level 2 to 5, and that is a description of the specific event that led to the abuse or the harm or the abuse and the harm that you experienced when attending the day school. So I guess that's where it's really important in level 2 to 5 claims to really provide as much description as you can. Because remember, the assessor or the administrator at Deloitte is going to be really looking closely at how you describe it and what occurred in assessing. That along with supporting documentation, if there is some, that's very important. And so again, if there is supporting documentation, that does have to be submitted with the claims form. But if not, and again, as I've been saying, if not available, you can use the Form 6 sworn declaration. Here's just a little bit of an administrator's update from Deloitte as of July 2020. They were giving some time estimates. They were saying at that point that level 1 claims are taking up to 6 months, can take up to 6 months to review and approve. The higher level 2 to 5 claims can take up to 12 months for the whole review and approval process. That's unfortunate. I know there's a lot of concern and dissatisfaction with this and frustration, and I get that, as we're frustrated with that as well. But I think it's really important for that not to impact the level of claim that you put forward, because what you don't want is down the road having only put in a level 1 claim because you didn't want to wait that extra time, or you didn't want to, or you didn't know how to deal with level 2 to 5. Once if you just put forward level 1, you may regret it afterwards, and changes. The administrator is also saying on their website that after June 15, 2020, you can't amend your claim. You can't claim for a higher amount. You can't put in a second claim form or application form. So again, it's really important to give thoughtful consideration to what happened to you at school and put forth your accurate claim. It's also important for the historical record, and I'll talk about that a little bit later. If you want your claim form to go in the legacy fund part of the settlement agreement, there is a historical record component to this process, so that the true stories of what occurred at day schools are available. It would be anonymously and all that, and I'm not sure the exact particulars of how they may or may not do that, but again, putting forth your truthful and full story, I think really does the best justice for day school students. Just like residential school students told their full story, and we heard a lot of it, non-Indigenous people and the country heard and learned a lot about what happened at residential schools. And we know that very similar abuses and harms occurred, same kind of things at day schools. So once the claim is submitted, and as I say, acting for survivors, we submit the claim and all of the supporting documentation, and we get confirmation. So we get immediate confirmation, we submit by email. Once the administrator does the assessment, they provide a separate letter giving the conclusion of what their decision is. So the first conclusion, I guess, is regarding eligibility, and then the next steps, if there are any. And the eligibility, again, goes to the issue of day schools, the school you attended, and also, as I said, your compensation, what level you claimed, and what the compensation award is. If it is deemed eligible, then you get a letter informing that you're eligible and that you either meet the criteria of the level that you sought, or the administrator may find on their review that actually you're entitled to a higher level than what you've claimed for. On that page I showed you, levels 1 to 5, and they may give you a higher level, or they may also thirdly decide that you don't meet the criteria, and then they might reduce your level. But it is very also important to give thoughtful consideration as to what level you seek. And that's sort of a strategic decision as well, because you want to seek a high enough level that if it's denied or downward, a reduction by the administrator to a lower level, that the path to a reconsideration or an appeal is still open. So, again, that's where having good legal advice on what level to claim and for what reasons, and really putting forth a good, clear narrative or story about what happened to you is really, really critical. So just briefly about the reconsideration process. What happens is if you when you get the decision from the administrator, and if it's lower than what you sought, a notice letter advises of your right to a reconsideration, which you have to do within 120 days of receiving that notice. And there's also a separate, sort of another level past that of a third-party review within 90 days if you're not successful your reconsideration. So, and there's some, you're invited to provide additional information at that time. And again, that's where it is really critical and where our expertise can really come into play. If you don't respond or don't seek reconsideration or an appeal within the time frame, then their decision is final. Just briefly, third-party review. You can also request a review by a third party. They can make a decision final or also send the application to the exceptions committee. And the exceptions committee is made up of representatives of Class Council, the Government of Canada, and of the survivor class. And claims are referred to them where, particulars are provided of abuse that wasn't contemplated in the harms grid or where the circumstances are exceptional and should be considered for compensation. So that's sort of another overarching narrow process for review. And those decisions are final of the exceptions committee. So just briefly on the estate and representative claims, and in this process, as I indicated, claims can be made not only for abuses done by school officials and teachers and nuns and priests and all of that, those adults that are associated with the school, but I also talked about student, non-student type of claims as well. There's also claims included for deceased family members who were survivors. The criteria for that is if the day school class member died on or after July 31st, 2007, the estate may be eligible to file a claim. There are some legalities to that, particularly when the survivor may have passed away without a will, and depending as well whether they live on and off reserve. So there's some particular legalities to estate claims potentially, and as I indicated, we can assist with those. That just talks a little bit about that in some more detail. And so I just want to conclude by briefly talking about some of the issues that have been in the news since January 2020 to do with this day schools claims process. The most recent, I guess, one of the most recent was, again, quite a lot of concern and dissatisfaction with the settlement process, I guess the compensation process. And here's where it's been raised, and we've been hearing it all along, that many survivors, finds the settlement process or this compensation process challenging, difficult, hard to maneuver and understand, and many, for that reason, for other reasons, have only claimed level 1, and kind of to get it over with. And so that's, a real shame and sadness, with those kind of things happening. Here's what I mentioned earlier, the media report, and it was on the administrator's website, that after June 15, 2020, survivors of Indian Day Schools will no longer be allowed to resubmit or change or modify the level of compensation that they're seeking with their claim form. This is really unfortunate as well, because we know a lot, and I experienced it a lot with over 400 residential school survivors that I worked with, is we know that these survivors, when they are recalling and reliving, these really, really unfortunate childhood events, they don't always remember things fully the first time. And so what occurs is what's called progressive disclosure. So, I've sat with many survivors and they tell me their story about, what occurred. And then maybe a week later, I might hear from them again, and they remember more, or they're more comfortable to tell me more, that kind of thing. And so, again, that's just another reason why, it is very important to really think carefully and take your time, in putting forth your claim. And we certainly take this approach in working with our, day school survivor clients, really taking into account that whole concept, or that whole progressive disclosure phenomenon. And so again, it's really, really important that your claim gets put forward fully and really providing the particulars that are necessary. That's just more about survivors being upset about wanting to change their level of harm after the claim was submitted. In July of 2020, Dene Chief from the Northwest Territory Dene Nation he and others, we're hearing many other Indigenous leadership speaking out in dissatisfaction about the compensation process. So he's asking for an independent review of this compensation process. So again, just more of what we've been hearing in terms of really concern about this compensation process. And so again, I think it is important that I guess as independent counsel assisting survivors in this compensation process, there's a lot of important work that we're doing. Again, we're seeing a lot of criticism and upset as well on, for example, this Indigenous Day School Survivor Information page. Again, along the same kind of lines, finding the process too long, not getting the help that they need. And again, I think the result of a lot of what we're hearing is that many survivors have submitted claims themselves and putting themselves at risk of not getting the full compensation that they may deserve. So just to finish off, again, I started by talking about the July 2020 court order allowing survivors to now choose to have their own legal counsel if they so desire. Representing yourself, I think level 1 is reasonable. The work that we're doing was we're assisting survivors at the higher levels. Again, the options are class counsel with their free legal advice. At the beginning, I provided how you can contact them. Deloitte has a call center. Many survivors that I've heard from have indicated dissatisfaction with that. It can be challenging to receive timely, satisfactory, and clear information. And then another option, choice is for your own independent legal counsel like ourselves. And so that's really an access to justice. And this is one of the reasons why this was fought for in the court. So there is a cost to this to retain us or others like us. For us, we're charging a 5% legal fee of any award plus HST. So there's no fee, though, if you don't receive compensation. So, an example might be where a survivor thinks that they're only level 1, they get good solid legal advice and support and assistance from us, and it may be that they're a level 4 or 5. So there could be a really big difference in the compensation that they're that they receive because good work and good legal advice was provided. Again, we're really good at knowing what supporting documentation that may be available that might assist you in your claim, again, to put your best claim forward to the administrator. We provide one-on-one confidential legal services. We'll also advocate for you under the reconsideration and third-party assessor process if required. And again, following up, as I indicated, we submit everything, make sure it's all complete directly to the administrator on your behalf. We're hearing a lot of claims coming back, which causes even much further delay because some of the necessary requirements weren't included in the claims, or ID wasn't provided, or those kind of things. And so I'm hearing that almost 30% of applications that have been submitted are being sent back to survivors because things were forgotten to be put in. So things like that can really slow down getting your decision or your award. So again, it's our job to put those applications and claims forward best with all the best information, making sure everything is there, and again, following up with the administrator to check on how your claim is proceeding and all of that. I had mentioned earlier about how important it is to put forward, the proper level of claim in your application. So I think that concludes my video here today. I really appreciate those of you that are going to review it. And if you have any questions or would just like to talk to us generally, we're happy to talk to anyone. Here's our contact information. We have a 1-855 toll-free number that's listed on this contact page. Michael and I both have our separate email, and our website is www.indiandayschoolclaims.ca. So thank you very much. It was a real pleasure to provide this information to you all.